everyone, and welcome to today's program, Lesser Known Species, a spotlight on neighboring and moral rights. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association, and today I'm delighted to introduce our speakers, Matthew Fulton and Joshua Graubart. Matt Fulton is the Director of Business Affairs at Writers House, where he guides film and theater adaptations, global publishing deals, and other intellectual property matters for one of the industry's leading literary agencies. He also teaches at Troy University's MBA in Music Industry program and serves on multiple copyright and literary property committees, reflecting his deep commitment to creators' rights. Josh Graubart is the principal attorney at the law offices of Joshua Graubart, where he represents U.S. and international clients in complex copyright and neighboring rights matters. He serves on multiple industry committees and boards, including ALAI's U.S. Executive Committee, reflecting his deep expertise in cross-border intellectual property issues. We're so excited to hear what they have to share with us today, so I'm going to turn it over to them.
Hi, thank you so much for having us. We're joining you today from New York City. So we're excited to have this bi-coastal presentation today. I'm just bringing up our slides now. Okay. Yeah, so as they mentioned, my name is Matt Fulton. I'm joined today by my colleague Joshua Graubart. And we're very excited to discuss the lesser known species of copyright law. Today, we're going to start with an introduction to copyright versus authors' rights regimes as they are found throughout the world. We'll go through what that looks like in the philosophical underpinnings of various regimes. Following that, we'll dive more deeply into moral rights, what they are, how they're presented globally in the various foreign authors' rights regimes, and then we'll take a look at how moral rights are presented in the United States, or a little foreshadowing here, if they are presented in the United States. Following that, I'll turn the time over to Josh, who will discuss neighboring rights, both in the U.S. and as they're addressed in international treaties. Following that, as is required and obligatory, we'll talk about artificial intelligence, which I'm sure everyone's really excited about, and how the topics that we discussed today are being affected by artificial intelligence. So with that, we'll talk about the regimes of author rights or copyright. The first one being the French model. So the first two here, the French model and the German model, the continental Europe models, are what we would call authors' rights, which I'll distinguish in a moment from the Anglo-American model, or what we call copyright. So the French model, droit d'auteur, is a dualist system. So essentially what that means is that it treats moral rights and economic rights as a separate set of rights. And I understand I haven't defined moral rights yet. We'll do so in a moment. The moral rights under the French model are inalienable and personal. They are inherent in the author, and they cannot be hypothecated away from the author. Whereas economic rights are transferable, but they're not as emphasized as moral rights under the philosophy of this model. Moral rights are perpetual; they last forever under this model, whereas economic rights are time limited. The French model can be found in France, France's former colonies, as well as Latin and South America, and the Arab world. The German model effectively has the same outcome as the French model in application, but there's differing philosophical underpinnings. The German model, or Urheberrecht, is a monist system. It treats moral rights and economic rights as one set of rights. You can think of the rights granted to an author as a coin, with one side being the moral rights and the other side being the economic rights. Under the German model, the work is seen as an extension of the author's personality, and it cannot be fully alienated, meaning you cannot, in the United States we would call a transfer, you cannot transfer your rights under the German model, but you could certainly license them and even exclusively license them. Since the rights are one and the same, the moral rights and economic rights are treated as one set of rights. Um, they're both time limited. Um, and as I mentioned, they're inalienable, meaning you can license, but you cannot assign. The German model can be found in Germany and Eastern Europe, Scandinavia, and there's a highly modified form of this in China and Japan. Finally, that brings me to the third model, which is the one that I imagine most of us here today are best familiar with, which is the Anglo-American model, or what we call copyright, which is a purely economic system. There's one set of rights, and it's economic rights. Um, the origins of the Anglo-American model are found in the Statute of Anne from the UK. The under this model, rights are framed as economic property only. The philosophy behind this model is to design is that it's designed to incentivize creativity for public benefit. There's no real acknowledgement of moral rights under the Anglo-American system, although, as we'll talk about in a moment, after the Berne Convention, jurisdictions that adhered to the Berne Convention or signed on to the Berne Convention had to kind of add an appendage to their system to cover moral rights, but they're not necessarily native to the model. Of course, the UK and Canada have adopted a system of moral rights through statutes, and we'll talk about how the United States has maybe or maybe not done that as well. The Anglo-American model can be found in the US and the UK and all or most former British colonies and most Commonwealth countries. I'll now turn the time over to my colleague Josh to discuss the Berne Convention.
Yeah, we should. So to begin, the Berne Convention is the great grandfather, if you will, of almost all subsequent intellectual property multilateral treaties. So it set in motion a number of concepts that have been incorporated into every other treaty. So it is well worth knowing, even if for that reason alone. But it has a long history, and this cartoon, which, by the way, a really lovely copy of which sits in Matt's office, is from an 1886 edition of the U.S. satirical magazine Puck, out of Boston. And I don't know if you can read, depending on how big your screen is, that the title at the bottom is "The Pirate Publisher," an international burlesque that has had the longest run in history. And the gentleman in the middle is the pirate publisher, surrounded by the various accusing parties who are all in different naval uniforms. And they are for a reason, pirate being the joke here. But in particular, I believe it's the fourth from the right with the mustache is W.S. Gilbert of Gilbert and Sullivan, the author of Pirates of Penzance, which had premiered in London, I believe, in 1878 and been widely pirated in the United States. It was performed by several touring companies, none of whom paid a dime in royalties to Gilbert or Sullivan. As a result of which, by the way, HMS Pinafore, I'm sorry, excuse me, I got these out of order. Pinafore was the one that premiered in 78. And Penzance then was premiered by Gilbert and Sullivan in New York, solely so that they could get some money from the U.S. run before they took it to London, because they had been so upset about the loss of all the revenue from the U.S. So the Pirates references to that, and there are in fact lyrics to an imaginary song below the chanting of the pirated and angry authors. The rest of the authors, in addition to Gilbert, are on the left are all Americans: Twain, John Greenleaf Whittier, Bret Harte, Oliver Wendell Holmes, the father, the poet, not the son, who was the jurist. And on the right, Tennyson, Wilkie Collins, Robert Browning, Gilbert, who are all British authors, Lord Tennyson. And somewhat in the back are the French, Émile Zola, Jules Verne. All of them are getting no money. And they're very upset about this. As a result of this, in the 70s and 80s, there was a movement to get some kind of international protection, especially in Europe. There was I believe it was an 1877 conference in which Victor Hugo, the author of The Hunchback of Notre Dame and others, served as the honorary president. And the working sessions were chaired by Ivan Turgenev, the Russian author of Fathers and Sons, to try and push governments into some kind of international protection. That met annually. That organization, by the way, is called the LAI, ALAI, the Association Littéraire Artistique Internationale, and it has grown into, over the many years, a kind of study group for international copyright. It meets annually to discuss various topics relating to international copyright protection. But its initial fruit was the Berne Convention, which was finalized in 1883 at a conference and adopted in 1886, and was revised about every 20 years through the 1970s. It has, at this point, it has so many members that unilateral amendment is, I'm sorry, excuse me, not unilateral. I forget, for some reason I'm grasping at the word that would cover all parties, but it doesn't say that. I'm sorry, unanimous was the word I was groping for there. It's thought that unanimous approval of any changes is going to be impossible. And so as a result, there has not been a substantial change in the Berne Convention since the 1970s. It has, however, been adopted in its entirety into the TRIPS agreement, with minus the moral rights provision at Article 6 bis at the behest of the United States. And most of its key provisions have been adopted into, as I mentioned, other copyright and IP provisions. The big ones are, I'm sorry, the sort of three key columns here are national treatment. The idea that every state party must treat every other state's party's authors as though they were their own authors. So France must treat German authors no worse than it treats its own authors, and vice versa. The second is minimum standards. Yes, it is true that you have to treat people no worse than you treat your own people, but you also can't treat your own people particularly badly in order to somehow achieve a policy purpose. There's a minimum standard you have to adhere to, minimum term, minimum levels of protection. Certain things must be protected, other things are optional. But there is a minimum standard that applies to all parties, that they must at least rise to this level. And then finally is the prohibition on formalities. This was, if not deliberately aimed at the UK and the US, it was a function that was common there. The idea that you had to register or send copies of your book to the Library of Congress or to the universities, as it was in England, in order to achieve copyright protection. The answer, the result was that you had to do nothing in order to receive copyright protection. The author simply had to create the work, period. And from that moment, copyright attached. You may ask yourself, well, but the US has registration. Yes, but US registration is not required for protection. It simply adds a bunch of goodies if you have it. But you have protection whether you have it or not, and it has been that way since the 1976 Act was adopted, anticipating US adherence to Berne, which finally took place 103 years after Berne was initially adopted in 1989. Matt, do you want to move to talk about moral rights? Well, I'll mention briefly moral rights. Moral rights were not in the original Berne Convention of 1886. They were adopted in the 1928 Rome revision, and they were adopted by all the members, but not always in the same way. The general theory is that they should be in the statute, and in many countries they are. But Britain did not actually put them into the statute until 1988. So for 60 years, Britain was adhering to the treaty by using a slightly different version, which Matt's going to talk about, passing off and some other related unfair competition rules to somehow make it appear, or indeed make it true, that it was adhering to the requirement for moral rights, but without incorporating it specifically into the copyright.
So before we get into an in-depth discussion about moral rights, I think there is a video that we'd like to share that may help illustrate some of the concerns that we'll talk about. And here it is.
You found the Clone Wars? Yes. I was once a Jedi Knight, the same as your father. He was the best star pilot in the galaxy. And a cunning warrior. I understand you've become quite a good pilot yourself. And he was a good friend. Which reminds me, I have something here for you. I have this when you were old enough. Say something.
For the astute Star Wars fans in the audience today, you may recognize that is not a clip of the original Star Wars film. So the story behind that was that this is a cut from a Chilean broadcast of Star Wars: A New Hope. To avoid cutting to commercial breaks, the sponsor for the broadcast just cut in or caused to be cut in internal commercials as if they were part of the plot of the film. So rather than Obi-Wan Kenobi handing Luke Skywalker a lightsaber, he hands him a beer. And there's a bunch of cuts that are just real comedic gold that are just happen throughout the movie. You can find them online. I just find the one that we showed to be the funniest one. Eventually, after this aired, George Lucas, as one would expect, took objection to this butchering of his work, filed suit to prevent it from being shown again. He ultimately didn't win on a moral rights claim, but won on an advertising claim, which leads us into how the U.S. protects moral rights, which we'll get to on the next slide. But we're almost 20 minutes into a presentation on moral rights, and we have not defined moral rights. So I think we should cut to the chase here. So the moral rights are non-economic rights that protect the personal and reputational interests of creators in their works. There's three main types of moral rights, with a fourth one that is implied from the three. The first one being the right of attribution or non-attribution. This is the right to be recognized or to reject recognition as the author of the work. There's the right of integrity, which is the right to prevent distortion, mutilation, or other derogatory treatment of the work. Interestingly, if there are any opera fans in the crowd today, there's this concept, especially in Germany, but in Europe, of Regie theater versus Werktreue. Werktreue being presentations of older operas as the composer and librettist intended them to be presented, and then Regie theater being presentation of old operas under new light, new scrutiny, putting the emphasis of the director's vision at the forefront. This explains the Met Opera in New York. I'm sure the LA Opera as well does this. You might see a Rigoletto or a La Boheme that's set in space or something. There are actually lawsuits in Europe, in Germany, where the heirs of Poulenc took objection to a Regie theater production. I might be butchering that pronunciation, but production of Dialogue of the Carmelites. It's very interesting. We won't get too much into that. I'm just such a dork that I had to share that. There's also the right of withdrawal, which is the right to withdraw work from circulation. From the right of withdrawal is the implied right of publication, right of first publication. This is the right to put the work out into the world or not. Famously, American composer Charles Ives used to sit at his piano and work on a piece and polish it and make edits, and then play it once, take the manuscript and throw it into the fire, because under his philosophy, he birthed the work into the world and it did not need to be performed again. So that he was exercising his right of withdrawal or his right of publication. So these are the main moral rights. Those of you that work in this area know that there are not any explicit protections for these rights in U.S. statutory copyright. So what the U.S. does is it has created what we call a patchwork of moral rights. So the U.S. looks to other areas of federal and state law to provide the same protections that would be afforded creators under a more traditional moral rights regime. Just before the adoption of the 1976 Copyright Act, when the U.S. was making steps to adhere to Berne, Congress commissioned a study to look into whether or not U.S. law was sufficient to provide the moral rights protections that are required under Article 6 bis of the Berne Convention. And ultimately, the result was that yes, the committee found that there is sufficient protection through this patchwork of moral rights. So I'm going to go through a little bit to show some. This isn't an exhaustive selection of how it's protected, but these are kind of the main ones that you'll hear talked about most often. So the first one is Gilliam v. ABC. So this happened in the mid 70s. Essentially, Monty Python, the creators of a sketch comedy show called The Flying Circus, Monty Python's Flying Circus, licensed their rights to the BBC, who then sub-licensed U.S. broadcasting rights to ABC. In order to get the shows to fit U.S. broadcasting standards, they needed to cut about 25 minutes of material from each episode, which altered the comedic pacing. It changed some of the jokes. Those of you that might be fans of Monty Python know that, or the Flying Circus more specifically, know that there are recurring jokes and recurring themes that happen throughout the episode and callbacks that, if taken out of order, really lose a lot of comedic effect. So after these edits were made without Monty Python's knowledge, they caught wind of the broadcast and they sued ABC for making these edits. Essentially, the Second Circuit held that unauthorized edits could constitute copyright infringement because they create a derivative work without the author's consent. They also made claims under the Lanham Act for passing off, meaning that this Monty Python derivative was a knockoff of the original, and this wasn't there. It was presented as if this was Monty Python, when in fact this wasn't. This was a bastardization of their art. The court acknowledged that U.S. copyright law did not recognize moral rights in the European sense, i.e. the right of integrity, which is what was mainly at issue here. But the decision effectively approximated moral rights by holding that through the derivative works laws and Lanham Act, the Lanham Act claim for false attribution, these theories of law were sufficient to protect the author's interests in preventing distortion or mutilation of their work. This case is often cited as the leading example of how U.S. courts fill in the gaps to protect moral rights, which brings us to another case, Daystar versus 20th Century Fox. Both of these cases are included in the reading materials that were distributed if you want a more deeper dive. So essentially in Daystar, after World War II, General Eisenhower published a memoir called The Crusade in Europe, which was a telling of his experiences during World War II. Shortly after publication, 20th Century Fox optioned or acquired rights to produce a 26-episode television series, also called Crusade in Europe. Under the 1909 Act, the producers did not apply for an extension term, so after 28 years, the work fell into the public domain. In the 1990s, the Daystar Corp purchased physical copies, video cassettes of the original TV series. They spliced and cut and edited the footage and repackaged the material into a new video set called World War II Campaigns in Europe that made no mention of Eisenhower, made no mention of the original 20th Century Fox, 20th Century Fox production. And then they sold it. So Fox and its partners sued under the Lanham Act for reverse passing off. This is selling someone else's work under your own label, and state unfair competition laws. They couldn't make a copyright claim like the derivative works rule in Gilliam because the work was in the public domain. So in the Supreme Court, in a unanimous decision written by Justice Scalia, held that the origin of goods, as it's used in Section 43A of the Lanham Act, refers to the producer of the physical goods, here the video cassettes, and not the author of the underlying creative content. The court stressed that Congress had not adopted a general attribution right, and using trademark law to protect authorship would improperly extend expired copyrights. So effectively, Daystar started to close the door on some of the legal reasoning in Gilliam, and makes clear that there are limits to moral rights protections in the United States, and perhaps showing that this patchwork has some flaws. To help address some of the flaws in this patchwork, the U.S. did adopt VARA in the 1990s, which did grant some explicit, and as far as I know, the only statutory explicitly moral rights provision in a statute. So VARA is a part of the Copyright Act that protects authors of works of visual art only. These are paintings, drawings, sculptures, still photographs that are in limited editions of 200 or fewer and signed and numbered. This does not apply to other areas of copyright like literary works, musical, audiovisual, mass-produced works even. And it granted some limited, sorry about that. It granted some limited moral rights. including, sorry, I lost my notes here in this scrolling, um, including the right of attribution, the right of integrity to prevent destruction, and then an even further destruction protection for works of recognized stature. There are certainly exceptions for works that are part of the architecture, and there's if you read the statute, there's a lot of exceptions and procedures. Here, the duration is only for the life of the author for individual works or for joint works until the death of the last surviving author. And as I mentioned, there are a lot of limitations here. It only applies to works of original art, of visual art, and excludes applied art like posters, maps, as well as motion pictures, books, etc. Which brings us to Section 1202 of the Digital Millennium Copyright Act, which pertains to digital rights management. This is the metadata that states who the copyright holder is, or technological measures that prevent piracy or other changes in the work. This is a bit of a stretch, but it does speak to the right of attribution, the right of integrity a bit. And then finally, looking forward, included in the materials was I guess this is looking back now, but the United States Copyright Office report from 2019, where they reevaluated moral rights and whether there was a need to adopt further statutory provisions. You'll see a more in-depth conversation of a lot of the cases that I talked about on this slide. And then also the same conclusion that the United States doesn't really need a statutory provision for moral rights that were covered under our patchwork. Before we move on to the next section, I'd just like to read this quote that ties in a lot of the concepts here. For the sake of legitimizing a hoped-for adherence to Byrne, one school of thought holds that by stitching together the state law paternity cases, state visual art statutes, the Monty Python case, and other scraps and fragments, we can fashion a loincloth, or at least a G-string, that will cover our moral rights nakedness. And that's from Ralph Brown in 1988. So with that, I'll turn the time over to Josh to discuss neighboring rights.
All right. So actually, Matt, can you flip back to slide 3 for just a minute? There we go. To go back to the roundels about the French and the German models, you will notice under the French model the words droit d'auteur, and under the German model Urheberrecht. These are both translations of the words author's rights. And author's rights, I think it's worth bringing up sort of two dichotomies here. The first dichotomy, of course, is economic rights versus moral rights, which Matt has spoken about. But the second one is author's rights versus, and here I'm going to be slightly coy, non-author's rights. Matt, if you go back to is it 9? I'm sorry, 8 rather. There we go. Neighboring rights. Non-authors' rights are neighboring rights, and they're not always called neighboring rights, but more frequently than not, in English and particularly in the United States, we use neighboring rights, which comes from the German. The concept is available in French, droit voisin, the related rights, or derechos conexos in Spanish, connected rights. These are rights that are not authors' rights, but sit next to them, or are related to them, or are connected to them. They're authors' rights like rights, but they're not actually authors' rights. It is somewhat difficult to define what they are, except by definition of what they aren't. And what they aren't is rather authors' rights. And it's hard to define what authors' rights are, but I'm going to have a stab at it, at least as a rule of thumb. Authors' rights begin to clash with copyright when you start to have multilateral copyright treaties where you have to deal with these kinds of distinctions. The British and American copyright system didn't really think in terms of authors' rights. And so when you start to have, on the one hand, the continental models, and on the other hand, the Anglo model, trying to work together to create something like Byrne, you have this dichotomy of definition. And in order to, it is helpful perhaps to put yourself in the mind of the 1880 legislator and artist and think, well, what do authors' rights adhere? And a good rule of thumb is Matt's already made a Poulenc reference, and I made a Gilbert and Sullivan reference. So to continue our opera theme, for those who are familiar with Puccini's La Bohème, an opera set in Bohemian Paris, of that period, I think it's the 1860s, and the various characters who are engaged in poetry and philosophy and painting in their artist garrets at the top floor of the apartment complex, if that's what you'd call it, top floor of the building, just under the eaves. Anything they could have made by themselves would qualify for author's rights. So the idea would be a painting, visual arts that can be done with a chisel or a paintbrush by a single author at home. A poem, a play, a novel, anything can be written by a pen. Other sort of a map, which could be done sort of by somebody at home with a pen. Anything of that nature, a musical composition, a person at home with his piano and a pen writing down things on sheet music. Those things qualify for author's rights. Everything else, with a gigantic asterisk we'll get to in a minute, isn't. It's something else. It's a neighboring right. And a lot of what initially only those things were what were covered by the Berne Convention. Everything else was outside of it. Those who are familiar with the Berne Convention will know that a couple of things that I didn't mention, which were either current in 1880 or about to become current, have weaseled their way into the Berne Convention, but in a sort of second-class status. Photography, which is a somewhat easier one to understand, in that you actually can do it kind of alone in your attic room, provided you can section off part of it as a dark room. But especially in its early days, involved a lot of equipment and technical know-how, and so I think was thought of as a kind of industrial process. The other one is cinematographic works, film and what is now television, which definitely is an industrial process. It involves lots of people. It requires a lot of money, but somewhat under the influence of the French auteur school of cinema, ultimately also sort of landed in French law and in the Berne Convention as being something subject to author's rights. Other things never made it in. And the one that's most obvious and the one that is almost always talked about in the United States whenever anybody mentions neighboring rights in the U.S. is almost always in the music industry, and almost always means simply performance of sound recordings, the monies that accrue to public performance of sound recordings under Section 106(6) of the Copyright Act. But it is a broader term than that. But sound recordings are one of those things that were thought of as being not really something that a single artist at his garret could do, and therefore subject to author's rights, a human right inherent in a human, but rather it's sort of industrial process. You got to go into the studio. There's a lot of expense involved. It's the kind of thing a company would do, and companies don't get moral rights to jump into match. They're not humans. They don't get author's rights. They're not really authors. This is a sort of property right that inheres an industry, and as a result, sound recordings have never been incorporated into the Berne Convention, and most author's rights systems don't think of them as author's rights. By the way, I will jump back just briefly because I did want to mention with respect to photography and film, they are included in Berne as author's rights. Not every jurisdiction treats them as author's rights, and both in Berne and most of the jurisdictions which do treat them as such, they are treated in a sort of second-class way. They don't get the same term. The standard term for author's right for most works in Berne is life of the author plus 50 years. But photography is, I believe, 25 years from fixation. That's your minimum standard. And film is 50 years from manufacture or publication. They are different standards. They're not really author's rights. They're sort of in there by courtesy, but they're not really there. Sound recordings have their own thing and are often outside of it. In addition to sound recordings, broadcasts and broadcast formats, think particularly in Europe, you have a lot of countries jumbled together with short borders. That means radio and television broadcasts are constantly leaking across national borders and can be easily pirated. So there was a thought to be a need to protect that. And then performances. Audio performances, of course, are fixed in sound recordings, and that sort of falls into that category. But other performances, live performances that are unfixed, or fixed performances in audiovisual works, are also perhaps neighboring or connected rights. They're not author's rights generally. Although, again, sometimes these lines can be elided. I have seen versions of this where part of it is author's rights. In other words, the performer has a sort of author's right in his performance, but the recording of that performance belongs to a film producer, for example, who doesn't have author's rights but has some sort of neighboring rights. It's an odd dichotomy that gets it's a sort of splicing of rights. But in any event, those are some common neighboring rights. There are possibly other things. It's not 100% clear where the boundaries of neighboring rights are, except to the extent that they are something other than author's rights that looks kind of like author's rights. So to jump to formalize a little bit more, if we can jump to the next slide, Matt, we can talk about three, and I actually will add a fourth convention that address these issues. The Rome Convention is the first one, and it deals with sound recordings and with broadcast formats. The U.S. is not and has never been a signatory to the Rome Convention. In 1961, there was no federal protection for sound recordings, and it was thought improper, I think, for the United States to adhere to a treaty when the federal government couldn't tell you what those rights were. They were, as those who followed the Flo and Eddie cases of the last 15 years may have noticed, never really well defined at state law. It fell to state law to protect sound recordings, but nobody really knew what the parameters of those protections were. And of course, they presumably would have varied state by state. All of this has sort of gone away because the introduction of the Music Modernization Act in 2018 brought all of those pre-existing out of federal copyright sound recordings into federal protection. But this is why we had a series of cases headed by Flo and Eddie in the last 10 or 15 years, trying to figure out what those rights were vis-a-vis what they should be paid from public performance. And it varied from state to state, and there was a really questionable notion of what these rights were, if they ever existed at all. But importantly, the U.S. did finally bring sound recordings into federal protection in 1972, leaving prior sound recordings hanging out there in state protection. But they never came back to Rome. They never said, now we have federal protection, we can sign on to the Rome Convention. We never did. This has real consequences that we're going to see in a minute. But to jump ahead, even though they didn't sign on to Rome, 35 years later, the U.S., now really a leader in copyright protection internationally, pushed ahead with two treaties. I mentioned earlier that the Berne Convention was thought to be essentially unamendable because by the 1970s or thereafter, because there were so many members now that to get unanimous approval would have been effectively impossible. So instead of doing that, the U.S. not just the U.S., but the U.S. was a motivating force, but a number of countries sort of said, we need to fix some things. There's sort of two, for those of us who are old enough to remember, copyright hobby horses in the 1990s were technological protection measures and copyright management information. These were going to be the tools that were going to protect copyright in a digital age. And as a result, the goal of these two treaties, which are the WIPO Copyright Treaty and the WIPO Phonograms and Performances Treaty, both of them 1996, was to put protections internationally on those additional parts that were not included in the Berne Convention or the Rome Convention. The idea that you were going to protect technological protection measures and copyright management information and a few other things. So the U.S., which never signed Rome, did in fact sign the WPPT, which includes some protection for sound recordings and broadcasts, and also, oddly enough, includes a moral rights provision to which the U.S. has made no effort to adhere whatsoever. But it is in there. It doesn't replace Rome. And one of the problems with U.S. non-adherence to Rome is that, for those familiar with 1066, which was put into force in the 90s, it added a public performance right for sound recordings, but a very limited right. It collects only for digital performance. Which for practical purposes means digital satellite radio, Sirius XM, or non-interactive streaming, which effectively means Pandora. And if it's streaming where, unlike, say, Apple Music or Spotify, you can't pick what you're going to listen to. You can just only pick, I'd like to listen to something like the Grateful Dead, or I'd like to listen to adult contemporary or some sort of genre, but you can't pick a particular song. So those two still fall under the 1066 performance right. But it's a fairly limited right. It doesn't cover things that are covered everywhere else, like live performance. You go to a stadium and and the loudspeaker plays a recording. The stadium will have to pay a license to the music for a license to the musical composition holder, the music publisher or the composer, but not to the record company or the sound recording performer. At least in the U.S. In Europe or elsewhere, they have to pay everyone. This is also true for terrestrial broadcasts. So for when the BBC broadcasts recorded music, it must pay PRS, which is the equivalent of ASCAP or BMI, for the musical composition. And it also must pay PPL, which is the equivalent of Sound Exchange in the U.S., collecting for the sound recording performance right. And this is also true for television, broadcast terrestrial television. But none of that is true in the U.S. So for broadcast radio, broadcast television, live performance, Sound Exchange cannot collect. There is no exclusive right under 106 belonging to those rights holders for that kind of public performance. This creates a problem because most performing societies work by reciprocity. You collect for our guys and you give the money to us, and we collect for your guys and we give the money to you. So normally, for example, PRS would collect monies for US sound recordings being performed in Britain and then send it over as appropriate to ASCAP or BMI or CSAC, and then vice versa. Those organizations would collect for British sourced recordings in the US and send it for distribution to PPL in the UK. But foreign societies may say, and some of them do, I'm collecting here for your terrestrial broadcasts. But why should I pay it to you? You're not paying it to us. Sound Exchange doesn't send us monies for terrestrial broadcast or live performance to the U.S. Why should I give it to Sound Exchange? So they don't. As a result of which, U.S. sound recordings rights holders and performers are unable to receive sometimes performance royalties for their performances that don't fall under the Rome Convention because they were recorded here. The USMCA, which I will add for everyone's general enlightenment, is more euphoniously referred to in Canada as CUSMA, the Canada-US-Mexico Agreement, which is the revision of NAFTA from the first Trump administration, includes, among many other provisions, a requirement that Canada and Mexico treat the U.S. as if it were a Rome Convention country for purposes of collecting and transmitting public performances. So when CBC, the Canadian Broadcasting Company, broadcasts a U.S. sourced sound recording, the Canadian societies must collect for that and transmit to the U.S. as if it were a Canadian sound recording and not a U.S. sound recording. And the same is also true in Mexico. Finally, one thing I will throw on here that is not on this chart, but which I think is worth mentioning, we've talked all about sound recordings and to a certain extent about broadcasts. What we haven't talked about is audiovisual performances. This was thought about as part of the WIPO Performances and Phonograms Treaty of 1996, but was pushed away to say, look, we'll handle that later. So negotiations began in 2000 for something which became the Beijing Audiovisual Performances Treaty. The U.S. signed it in 2012, but has never ratified. And it doesn't look like that's going to happen anytime soon. However, a bunch of other countries have, and from 2020, it's entered into force. What this means is that, unlike in the U.S., and for those of us who remember Google versus Garcia, in which the Ninth Circuit en banc reversed itself, or reversed an earlier panel to say, no, actors have no copyright in their performances. Other jurisdictions, Argentina for one, off the top of my head, have specific rights adhering to performers in their performances. And sometimes those are pushed to the performer, sometimes they are accorded to the producer of the film, and sometimes they're split down the middle to both. But be aware that in many jurisdictions where the actors themselves or other performers on stage, comedians, musicians in an audiovisual work, have rights in their audiovisual performances that don't exist in the United States. Can we flip to slide 10?
Yes.
We come to artificial intelligence. Go ahead.
Yeah, it's everyone's favorite part of a 2026 CLE, the obligatory discussion on artificial intelligence. While saving time, I know we have 15 minutes left for questions. I'm actually going to take this opportunity to answer one of the questions in the chat because it'll nicely guide into this part of the discussion. So Maxwell Herrera asks, do you think some moral rights from EU countries might be beneficial here in the USA? Perhaps it would help protect writers and others in New York City and Hollywood to combat AI dangers. I think that adopting moral rights certainly could help protect creators in the wave of artificial intelligence. And one way that could be done is by affording and this is kind of an amalgamation of a neighboring right and a moral right, by affording attribution, mandatory, compulsory attribution for AI bots. So to kind of illustrate this, as I'm sure many of the copyright practitioners in the room today have been tracking, shortly before Shira Perlmutter was purportedly terminated as the Registrar of Copyrights, the Copyright Office issued several papers discussing artificial intelligence and copyright. And one of their conclusions was that the outputs of an LLM, the large language model, is not eligible for copyright because it's not sufficiently it's not created by human and sufficiently creative. So what that's required is in the registration process. Copyright holders now need to identify portions of their work which were created using artificial intelligence. And as one of our colleagues in the Copyright Society pointed out at the Copyright and Tech Conference last fall here in New York City, this creates kind of a wonky incentive structure. Because what you're on one hand doing is requiring applicants to go through and do the work of identifying what was created by AI, which in many cases with how folks are implementing AI into their workflow is quite tedious to kind of identify what that is. But once they put that work in, what they are doing is removing protection from their work. So you're asking creators to work to get less of a copyright. So one proposal is, I don't know if anyone's actually proposed this. Someone probably has. Someone much smarter than me has probably thought about this much harder. But what my thoughts are, if we provide attribution rights to LLM bots, meaning like when works are published, if or when they're registered, if you identify it, the person that is utilizing this is the neighboring rights part of it. The person that's utilizing the output for their original work gets some form of limited protection in that work, while also identifying that this was created by AI. And I think this accomplishes a few things. One, if you know that it's AI and you like the way that this was written, then you can go, it's free advertising, it's good advertising for the LLM, it encourages the development of decent, good LLMs, which we've seen some of them are better than others. There's product liabilities issues here, where if something dangerous comes from an LLM, we know where it came from. And also it protects the consumers, which I think we'll see a lot of trends of, that people, if they knowingly have the choice between consuming human created content and content that's been created by a robot, I think many people are going to choose the work that was created by a human, just out of principle, whether or not that work has more merit or less than that created by the robot. So that's just one example of how I think that moral rights can help protect creators in the United States. Of course, maybe now is a better time than any for us to adopt moral rights, but I think we've seen, hundreds of years of reluctance on the U.S.'s part, on Congress's part, to formally adopt explicit moral rights. I'll turn it over to Josh to talk about some other applications and neighboring rights.
So one thing I found very interesting. A colleague of mine pointed this out to me a year or two ago at a conference in Berlin. One would have thought that given the European and the continental model sort of exaltation of the author as a genius creator, a human, and indeed the theoretical underpinning of the French and German models is copyright as a natural right inherent in the author, that the work is a spiritual child of the author. This is not an economic right. It's a natural human right, and it adheres in humans. Given that as a sort of basis, that Europe will be at least as resistant as the United States has been to granting copyright, or rather authors' rights, to computer-generated work. But that thinking only gets you so far when you remember that the Europeans, well, not just the Europeans, most of the rest of the world takes the difference between authors' rights and neighboring rights quite seriously. Neighboring rights have never had this sort of human rights underpinning to them. They're just economic rights belonging to a creator. Belonging to a producer, an economic. So we look at, to sort of take it back, I mentioned that the WPPT, the WIPO Phonograms and Performances Treaty of 1996, has a moral rights provision. In that, there are rights granted to both the producer and the performer. Economic rights go to the producer, but moral rights go to the performer. And they're completely separate in the sort of French model of a dualist system where there are two sets of rights. But it explicitly affords moral rights to the performers of phonograms, which is to say sound recordings. A right of attribution, a right of integrity. But who is the performer of a computer generated work. And some of you may know that there is I'm going to use the word performer here in enormous scare quotes, under the name Hatsune Miku, which is she is a Japanese pop star who is not a real person. It's a computer generated icon. She's touring this year in Chicago and Newark and a couple of other places. And she's a character, a sort of cartoon character that's projected up on a screen and then dances around while a synthesized voice sings her songs. So who is this performer who's going to get these moral rights under the WPPT? Under UK law, there is actually a specific requirement. It's Section 9.3 of the Copyright Designs and Patents Act 1988. Computer generated works do actually get authors' rights, not neighboring rights, authors' rights, but they've explicitly disclaimed any moral rights protection. But taking that outside, putting it in sort of even the continental model, where they haven't explicitly said, well, computer generated works will get authors' rights, I suspect they won't. But sound recordings have never been subject to authors' rights. They've simply accorded to whoever the producer is. I think the Hatsune Miku example would be a good one. Whatever rights there are, just adhere to whoever the industrial entity that created it, or put in place the situation where it can be created. So the U.S. has, because it doesn't make a substantive distinction between authors' rights and neighboring rights, has simply said, no, anything that's created by a machine cannot have any kind of copyright, without distinguishing between the sort of authors' rights regimes and the neighboring right regime. So we may see a divergence between the continental models and the U.S. model, particularly the U.S. model, as to whether or not, at least in neighboring rights circumstances, whether AI-generated works can have economic or moral rights attached to them. I'd be interested to see how the moral rights thing plays out.
Yeah, there are a lot of questions about how, I mean, it seemed the world of artificial intelligence, especially from a legal standpoint, is certainly still the Wild West, which we're speaking to Californians here, so maybe that's not a PC term that we use out in New York, calling the web. But with that, we would love to stay connected. The QR codes beneath our respective pictures will take you to our LinkedIn page. We would love to continue the conversation. Please feel free to reach out to us, add us, message us. Stay in contact however you'd like. With that, I know there are a few questions in the Q&A. If there are any more, please feel free to type them out and we'll do our best to answer them in the next 6 minutes. Josh, just scrolling through these, I see one question that I think you would like to answer just based on our conversations. This is from Jay Doherty. Can a U.S. record company and/or recording artist obtain payments from, e.g., European broadcasts or digital transmissions of their recordings? How could they do that?
First, hi, Jay. I haven't seen you in years, but I hope you're well. Secondly, as I understand the question is, how can U.S. artists obtain payment for performances overseas? Is that the question?
I think so, yeah.
Okay. You can obtain them through Sound Exchange. If a U.S. artist is a member of Sound Exchange will receive some money from overseas. Some foreign collecting societies for sound recording performance will just hand over the money regardless of the lack of reciprocity, or under law, for example, under CUSMA, where the Canadians and the Mexicans have to do it whether they want to or not. But another way to deal with it is to join Sound Exchange, but limit Sound Exchange collections solely for the United States, and then join a foreign society for foreign collections. So you could say, I'm a member of Sound Exchange for U.S. performances, but Sound Exchange is not allowed to collect anywhere else in the world. And instead, I will separately become a member of PPL, the UK's collecting society, and say, hey, PPL, you collect every place that isn't the United States for me. So they'll collect for the British performances, but then also through their reciprocity agreements, will collect for around the world. Another way to do this, I am told, is to record, even as a U.S. Citizen and a U.S. artist, if you go and record in a Rome Convention country, that recording is a Rome Convention recording and is subject to collection as if it were as if you were not an American. So that is another route, is to send recording artists to say go record in Canada or Britain and do it that way.
Just as a side note, I'm scrolling through the attendees here, and I see that my former professor Marshall is in the audience. So hi, Professor Silverbritz. Good to see you. I'm so honored that you joined. Another question from Dean Serwin. regarding non-interactive performance, what is Spotify when it goes into radio mode, playing things that others who selected what I did might have also played, i.e., things that I might also like? I think the answer to that, Josh, correct me if I'm wrong, is that when you go into radio mode into Spotify, it's treated it's the same thing as Pandora. It is treated the way that Josh described with the non-interactive. It's when you use Spotify in what we think of as maybe the traditional sense, where you are selecting exactly what song you'd like to be played, that it becomes non-interactive media. Anything else to add, Josh?
No, I think that's right. There is, I believe, there's a certain set of standards that are put, and I've looked into this once some years ago, in the Copyright Act that sort of define how you have to behave as a transmitter to fall into the non-interactive category. You can't have sort of the same artist over and over again. You have to divide it up within X number of hours. You can't perform the same artist again or the same song again. There's a whole rule. It looks actually, oddly enough, like the kind of internal policies we had at a radio station I worked at in the 1990s. Like, don't bore the listeners. Don't just play the same stuff over and over again. But adopted for the purpose of essentially avoiding a Spotify-like service. I should say the specific thing that Dean mentions, and by the way, hi Dean, that I don't know Spotify's particular thing because I'm not a Spotify user. But I agree with you. It sounds like they're sort of, they have an interactive and a non-interactive service. The interactive service is substitutes for purchasing. Gee, I'm not going to buy this record. I can just play it on Spotify whenever I want to. And then alternatively, the interactive, it's like radio. I turn it on and I have a general idea what I'm getting. I'm not going to get classical on the classic rock station, but I can't pick the particular thing they're going to play me next.
I think we have time for maybe one or two more. Josh, this looks like a comparative law question that you would be perfect at answering. This is also from Jay Doherty. Can a U.S. company be transferred the economic rights in a German authored work? What would a typical assignment agreement accomplish? How would a typical assignment agreement accomplish that? What about a work made for hire with alternate assignment agreements? I.e., how does choice of law work here?
That question is, I can only take the first part of it. The second one is so long and complicated, I can't even attempt to tackle it in the amount of time, although it is a very interesting question. The first one I will answer by saying two things. One, and I usually say this at the start of every presentation, I'm not a German lawyer. I'm not an international lawyer per se. I'm only admitted in 3 U.S. jurisdictions. But I am told by European lawyers that the German model, which applies not just in Germany, but in a number of Germans, all the German-speaking territories of Austria, Switzerland, but also most of Eastern Europe, the Nordic countries, and in a highly modified form, East Asia, prohibits actual assignment of a copyright. You cannot assign it, and to the extent you try to do so, it's a nullity. It's a non-transfer. You can, however, license exclusively for life of copyright, which is for all intents and purposes an assignment, but it isn't formally an assignment. So I think the best practice is to, if you were going to say, I want these rights, the author conveys to me or assigns to me all rights, and if that fails, it grants it a life of copyright exclusive license to me for the same work, which is for almost all intents and purposes the same, but avoids the problem that an actual assignment is apparently a nullity under German law.
Okay, so that takes us to 2:00. Thank you guys so much for joining. We were honored to present to Beverly Hills. Please stay in touch. Thank you so much.